All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. The room is shifting this way. Good afternoon. We are here on our case number 1CACV160174, Twin City Fire Insurance Company versus Leija. As you all know, the appellants and the appellee, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to use some time, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount that you have remaining, including what you have decided to reserve. We record these proceedings, so we'd be grateful to you if you would please, when you approach the podium, identify yourself and give us the name of your clients. We have read the briefs, we've studied the record, and we've also discussed the case in our conference. So with that, you may proceed.
Thank you,
I don't think I have a sign-in sheet. Thank you.
Joel Robbins for Graciela Leija, with a special appearance by David Abney.
Thank you.
May it please the court, counsel, I represent Graciela Leija, whose husband was killed primarily because of the fault of his employer. He was a window washer, and as part of his window washing duties, he was responsible for operating a machine called a mule, which rolled along the side of a building with his coworker suspended down from the bottom of it, washing windows. And his job was to roll the device there, but the device had been put together by his co-employee, Forrest Stockman. After the death of Mr. Leija, they went up to the top of the building and they looked around. And what they found were the bolts that should have been holding this device together, but which had not been placed there by the coworker who had not been trained. The mule was not tied off to the roof, and this was all part of a 6-count complaint of the Industrial Commission against the employer in this case. Unlike the Aitken case, this case deals with a case where the insurance company for the employer double collected. On the one hand, the liability insurer didn't have to pay anything because they had a workers' compensation bar. On the other hand, the Industrial Commission or the workers' compensation carrier now claims that they get all of their money back, even though the accident was undoubtedly caused by, in part, the employer. It is not like Aitken because there is no trial that preceded this action, but like Aitken, there is a verdict that can eventually occur. There's nothing in Aitken that says that the verdict has to precede the negotiations with the insurance company. Unlike the later cases, we did get permission from the workers' compensation carrier.
So the carrier approved the first two settlements, approved the settlement with Out West and Werner's, correct?
Yes.
And I'm not sure our record says that the carrier, what I have written down is the carrier didn't object to the lump sum paid by the other 4 third-party defendants. Is that
at the bottom of page 46 and 47 of the answering brief, the defendants quote the lower court, which found in the order dismissing the case that there was an agreement to compromise, but only after the third-party settlements were resolved. So yes, even the court found that. That is not really in contest, although the defendants now seem to claim that it was not, or that it wasn't in contest.
We'll ask about that.
Okay.
Then Aitken is one thing, but Stout is another.
Absolutely.
Tell us what is in the record that shows us that any of these third-party defendants settled at an amount from which we can infer there was some recognition that ultimately this defendant would have to pay less because of employer fault?
Well, in Stout, that was one that was limited by the policy limit. And in this case, the city of Glendale provides an umbrella coverage for everybody. As the owner of the property, under Arizona law, they become basically the insurers for the property. So they have basically, as a municipal corporation, an unlimited amount of insurance. The only monies that were collected were from the subcontractors for the city that had been responsible either for the purchase, the management of the building, those type of things. But the city never tapped its insurance policy and basically had an unlimited insurance policy, unlike Stout, that was limited by a $1 million insurance policy.
Where do we find that fact in the record?
Well, I guess beginning on the front page of the complaint, that was a suit against the city of Glendale, a municipal corporation, as owner of the properties. So we have basically the distinction right in the beginning of the case, and I believe it carried on throughout the case. I believe we pointed that out in our briefs.
I guess I'm just not following, though, the notion that Glendale could have paid more but didn't.
Right. Well, and so
how do we know that?
Unlike the situation where we have, in Stout, where they said there's $1 million policy, they offered the $1 million policy, therefore it's unrelated. In this case, the insurance companies for all of the subs had offered their policy limits, but City of Glendale never tapped its amount of insurance, which in essence is unlimited.
So, okay. So is it correct that the subs, Landa and Landcorp, those companies did pay policy limits?
Correct.
But
the city didn't chip in one penny.
The city of Glendale paid nothing.
Correct. As the umbrella insurer for all of these, and as the deep pocket, they had the ability to pay more. But we, as
and is that fact reflected in the record anywhere?
Yes.
Who paid what?
Well,
I mean,
I believe that was in the lower court. I'll dig that out.
Okay.
But I think the most important thing is to know that it's an umbrella above all of those, and it's a municipal entity. So in essence, it has an unlimited deep pocket to pay whatever was there. But
Okay.
Unfortunately, because we have the 3 citations by the Industrial Commission against the employer, the widow is put into an unbearable position of taking less money.
Right.
Two-thirds. Okay.
What kind of a proceeding were you asking Judge Herod to hold?
Basically, what we were asking was to hold the objectively reasonable third-party determination of basically allowing the insurance company to come forward and say this was not the employer's fault, and having us come forward and say, yes, it was the employer's fault.
Would that be a jury trial?
It could be a jury trial. It could be a hearing in front of the judge, so long as it is in front of a neutral fact finder with 2 motivated parties. In Stout and Grijalva, you don't have the 2 motivated parties. You have the one party that wants to get out of the lien, and you have the other party that wants to settle the case and wants to get out of the lien, in essence. So you didn't have the adversarial proceeding like we would in this case, where the insurance company has every incentive to try to point the finger at everyone but the insurance company for the employer, and we want to point the finger at the employer. But we've already litigated this case. We've already done disclosures that say it's this person's fault, this person's fault, somewhat like the medical malpractice case where one of the defendants settles the case, and then you're left with saying, well, you're a hypocrite. And we come forward and say, no, we're not, because our experts said that it was part the employer's fault. You couldn't deny it under these facts that the employer had some fault, and that was...
So, any allocation of fault that might have been mentioned or generated or maybe documented in the course of the settlements would not bind would not bind Twin Cities here.
Oh, not at all. We
at all.
couldn't bind them, or else it would become like Grijalva. It would become kind of the sham deal,
Right,
and we
right.
don't want a sham.
Now,
we want...
Yes, that I understand. On this, in negotiating the settlements, and I'm not asking you to go into things that are not part of the record, but just with our hypothetical plaintiff attempting to negotiate the settlements with the other defendants, and to document that the employer's fault affected the settlements, how would that be done?
Yes, very good question, Judge Norris. The way it would be done is to go to a trial of some sort, whether it be in front of a judge or a jury, and say, what's the total amount of damages? In this case, I think Graciela received $500,000, but let's say that they said that it was worth zero. Let's say that, oh, his life was worth nothing. Well, then I guess by that reasoning, they would get a full credit. They would get all the money that they deserve. If they said it was worth $5 million, however, and they said that 10% of it was the fault of the employer, then you take your calculator out, 5 million times 10%, $500,000 would be the amount that they would have to chip in. And in essence, then Graciela would get the money that was in the bank and would continue to get benefits until that $500,000 was exhausted. And at that point, she would begin to give them a future credit. So it would be determined by a jury with the proper parties, with the proper incentives making the arguments.
I want to make sure I understand the answer to Judge Johnson's question. Did you say that the city of Glendale paid nothing?
It isn't within the record, but that is the truth.
And then were they dismissed?
Everyone was dismissed. All the parties were dismissed at the same time.
So the hearing that you're requesting, that you requested Judge Herritt, that would strictly be between Twin City and the Leijas?
Correct, because they would have the motivation to point the finger at everyone. But armed with the admissions, any admissions and depositions that we took in the underlying case, we have the comfortable position of not being hypocrites because we always acknowledged that there was some fault on the part of the employer. We never said different, but we would be allowed to present that either to the judge or the jury, and they would be allowed to present any evidence because they kind of have open field running. They can come in late and say, well, we blame everyone but the employer.
So you could conceivably, either in this case or another one, you could use all the discovery that was generated or not, depending on what the trial court found in accordance with the carrier's due process rights.
Correct. We had every motivation in the world when we were trying to establish the liability of the defendants to go and dig and find facts that were adverse to them. It was actually the defendants that were the ones pointing the finger, but doing the discovery that we would then step into the shoes of. So both they step into our shoes and we step into the defendant's shoes in some sense, but we also have never been hypocrites about this. We've never been saying, oh, this is all the fault of everyone but the employer or the co-employee who literally his Copenhagen can was found next to the bolts that weren't put into the machine.
In view of Stout and Grijalva, how can we say that Judge Herritt erred by denying the motion for summary judgment on your claim for breach of the duty of good faith and fair dealing?
Because under Stout and Grijalva, there are three distinctions. One that is common to both of them, and one that is special to Grijalva, and one that's special to Stout. The one that's common to both of them is in both Grijalva and Stout, the plaintiffs in those underlying cases had violated ARS 23-1023C when they did not get the permission of the carrier to make the settlement in the first place. In this case, we went to them and we said, we are not going to settle this case with you. I mean, they're taking a haircut, 5%. It isn't even what you would give a moderately competent waiter or waitress when you order your food, and that's the compromise they offer, unlike Stout, where they offer to waive 2/3 of the lien. But in this case, we got their permission, so you don't have to deal with Stout, and you don't have to deal with Grijalva.
But there's language in Stout that says, absent a jury verdict, you don't have to do anything. The carrier doesn't have to do anything. How, in view of that?
Because we will have a jury verdict. Because when this case, I believe that the court's concern, and I believe that if we use as a guiding star the Aitken case, and we say, what is the purpose of it? The purpose of it is to promote people suing third parties. And if we determine that Stout, which they said in the case itself, that they had not gotten permission under ARS 23-1023, which under Grijalva was the deal killer. They said, if you don't have permission of the carrier, you're done. You haven't followed the statute, and you don't get to now start saying that they owe you anything. You violated your duty to them, and we didn't do that. Now, in Grijalva, it was the one with the sham pleading, where in this one we're just asking that we both go with the proper motivations. And under Stout, it was limited to there was only the policy limit available, whereas in this case we had basically a limitless policy that we had to settle, which reflects the facts that weren't at play in Stout.
What I was asking, or what I meant to ask about was, separate and apart from the claim for an adjudication, there was a claim for breach of the duty of good faith. Correct. For failing to give equal consideration.
Yes.
And I'm wondering how, in view of the case law, we can hold that that such a duty existed at the time.
And the place where it becomes, I think, the duty of good faith becomes important in this particular case is the promise. We'll deal with this later. Because we change, in essence, our position in reliance on them saying, okay, we'll work this out later. So we change our position. We say, because if you saw in the briefing, we said literally, we will go to trial and we will lose this case because we can't accept the terms that you've given. And they say, okay, we agree. You settle the case. Let's kick the can down the road a ways.
Do you have a specific reference in the record to support that statement?
I do.
And I will tell you because I have looked insofar as I could figure out your citation. When I say you, I mean I'm dumping on all parties here. Your citations to the record, which I found confusing. I've looked at the letters. I've looked at some of the emails. And what I found was basically, this is my terminology, an intransigent insurance carrier who basically said, we're not going to go along. We'll deal with you later. But I didn't see anything that said, we'll take care of this issue and we will adjust it and we will reach an accommodation with you later. I didn't see that.
Okay. Yes, there is, I mean, basically, again, at pages 46, bottom of page 46 and the top of page 47 of the defendant's brief, it talks about the ruling from the lower court, which said, it is also undisputed that all of its communications, Twin City consistently advised that it would not reduce its lien based on some non-judicial determination of employer fault, and further that it was willing to consider some compromise, but only after the third party cases
That
were
just
resolved.
basically says, I'm willing to get up in the morning and talk with you. That's not a promise or a commitment to really come to the table in good faith and bargain.
But that's when we change our position, when their promise induces us to change our position. If that was what they intended, was just to say, hey, we're going to let you waive your right to a jury trial, and then we're just going to laugh at you when you ask us to compromise, that's where the bad faith comes in.
Well,
and
is there a fact issue? Because and I'm not at all being facetious.
No, and I understand.
But is there
that,
maybe a fact issue that should go to the jury on that? Because the way I read mostly Mr. Howe's letters and emails, it was basically, it's my way or the highway. You go do your thing.
But then they shouldn't ever give permission to settle the case.
Well, I recognize that too.
Because that's the inherent inconsistency of it. Is we're saying we're both, we are two, an immovable object meeting an irresistible force, and something's got to give. And they blinked. If they didn't intend to do anything, they needed to say, we intend to do nothing. You will not.
Let me ask a question. And
sure.
Again, if you during Ms. Vopel's time, maybe you'll have a citation to the record. Is there a letter or an email that Ms. Leija's counsel sent to Mr. Howe or one of his colleagues that said, we are going to settle with A or B, I don't think it matters, based on your representations or assurances or whatever nouns you'd like to use, that you will resolve this matter with us and take into account employer fault.
There
and
is
therefore,
nothing.
Based on that, excuse me,
Yes.
sir, based on that, we have gone forward with our negotiations. We are relying on you to do this. Words to that effect. Where would I look for that?
You would look nowhere. You
Okay.
will not find it. I apologize. That's the only reason I was cutting you off. I apologize.
No,
I
that's
could see
okay.
where
Don't
you were
worry
heading,
about
and
it.
I wanted to make that
I
admission.
bet you Judge Johnson will give you another couple of minutes if we're nice.
Well,
Okay.
I appreciate that. So I will reserve the remainder of my minute 40.
Okay.
Thank you.
Thank you.
Ms. Vogel.
Good afternoon. I'm Lori Vogel, counsel for Twin City, the workers' compensation carrier in this case. This case should be affirmed for 3 reasons. Number 1, Aitken and its progeny make clear that a workers' compensation carrier is not required, although it may, compromise, reduce, change the value, however you want to put it, its lien, where there is no judicial determination of employer fault. That is crystal clear. Number 2, Grijalva and Stout make clear that the employee is not entitled to a post hoc hearing, trial, after the settlement that is designed solely for the purpose of compromising or forcing the carrier to compromise its lien, regardless of what you call it here. Now, they initially were talking about an evidentiary hearing. Now they're talking about a full-blown trial. Then why not go to trial in the first instance? Regardless, in Stout 2, this court made very clear that the reason it's a sham proceeding, and Grijalva alluded to this as well, the reason that would be a sham proceeding is because the motivation of the employee is different. The motivation of an employee in a third-party trial without settlement is to minimize the employer fault for purposes of maximizing the liability of the other third parties. No matter who is involved, whether it's one of the third parties with the employee or the carrier against the employee, Grijalva and Stout make clear that the carrier cannot be put into a position through that kind of an ad hoc proceeding for solely for the purpose of reducing the lien, because the employee's goal and motivation in that kind of proceeding is the exact opposite of what it would be in a real trial for liability and apportionment, and that is to maximize the employer fault for purposes of reducing the lien.
I think we all have questions about that.
Okay.
What's your third point, just to get it out?
Oh, I'm sorry. Yes, the third point is that there's no evidence supporting Ms. Leija's assertion here that we made some kind of a promise to compromise the lien and then failed to negotiate in good faith. We actually did negotiate in good faith, and the record shows that.
Oh, really? Oh, really?
Yes, Your Honor. Actually, it does. Because ultimately, Ms. Leija was offered, and it's in writing, the exact same compromises and percentage of compromise that Mr. Stockman was. If you look at Exhibit P, first of all, that deals with the second settlement. The first settlement, obviously, there was an accepted compromise of the lien.
Exhibit P to what?
Pardon me?
Exhibit P
Exhibit P to our statement of facts in support of our motion for summary judgment. And that specifically shows that is a letter, February 11th, 2011, where Mr. Howell makes the exact same offer to compromise the lien for 20% of the amount collected. He agreed to do that with Ms. Leija. It's in writing. And unfortunately, those negotiations broke down because plaintiff's counsel continued to take the position that we were required to reduce it based on some unadjudicated percentage of employer fault. As to the third settlement, if you look at Exhibit AA to our statement of facts in support of our motion, it shows our willingness in extending the same offer to reduce and compromise our lien by 5%, the exact offer that was made to Mr. Stockman. And although there were some emails internally flying around, and although we were taking a little more of a hardline position initially, we did negotiate that in good faith. What we did not agree to do was, and we made this clear in letter after letter after letter, was to voluntarily reduce our lien based on some percentage of employer fault. But we did agree to compromise the lien. Now, as far as whether there was a whether we gave permission or consent. What the statute requires of a worker, we're not the liability insurer here. And so it's a different level of consent, and consent comes into play at a different point. The statute, our only interest in it, we never made an appearance. We didn't fund it. We weren't involved in the third-party suit. Our only interest was protecting our lien. And the statute recognizes that by requiring that, and I'll read the exact words, compromise of any claim by the employee or the employee's dependents at an amount less than the compensation benefits provided for shall be made only with written approval of the insurance carrier.
Is there any issue about whether that the plaintiffs violated that statute in this case?
No, and in
Okay.
fact, our position is, the first one was for less, clearly, and we did give, and that was settled,
Okay,
that was
just wanted-
negotiated.
okay.
But after that, it was clear we knew that there were a lot more people, a lot more third parties out there, and although we didn't object to it, we didn't have to consent because we were not willing. What they had to get consent to was for us to agree to compromise our lien. And we did not agree to do that at any point. And even Mr. Stockman's counsel, Mr. Slack, made that crystal clear that his understanding, even as to his own client, was that we might come after the fact and ask for 100%.
So this case is unlike the prior cases, and I'm not remembering that I think it may have been Stout too. This is unlike the prior cases in which the injured worker settled with a third party in an amount less than the lien without the consent of the carrier.
Correct.
Okay. Now, why?
But that doesn't matter.
Right.
That's our position, is that doesn't
Okay.
matter.
Why, I understand your Aitken and Stout and Grijalva, the latter two in particular, talked about sham proceedings and whatnot. But it seems to me the concern that you're talking about, that the incentives are skewed, would not come into play in the sort of proceeding that the plaintiff sought here, or not the plaintiffs, the injured worker sought here. The proceeding that they asked for here would allow Twin City to put on whatever evidence it wants to show that the third parties, not the employer, should bear the majority of the fault.
It is clear that and that was the point I was trying to make earlier, the employee's motivation is different. That's what makes it a sham proceeding. And while we might be there
Well, how
defending
would it be sham?
it,
Because the court's going to rule on it, a jury's going to rule on it, the court's going to rule on it.
because the
Everyone's gonna have a chance to
entire
weigh in
motive,
and get any due
because
process
the
they
entire
want.
motivation in a liability trial without settlement is that the employee's goal is to minimize the employer fault. In this
So
kind of
what?
a proceeding, it is to maximize it.
So what? If you have
That-
a jury verdict, if you have, isn't the point of Aitken that the carrier is entitled to a lien only, now I'm going to say this backwards if I'm not careful, is not entitled to collect more than its percentage of fault. And so if we have a jury verdict that ascertains that amount, then so what? I guess I'm not understanding what the harm is.
What the harm is, Your Honor, is that this Grijalva specifically talks about, and this court recognized that in Stout, that Aitken concerned the lien rights of a workers' comp carrier following a contested third-party trial that necessitated a determination of liability and damages, including the apportionment of fault as required by law. There was no advance agreement, and they say, and it talks about the summary trial was of no consequence. It doesn't emphasize, well, because the carrier's not involved. Grijalva emphasizes because its only apparent purpose was to diminish or entirely defeat the fund's lien. That's what is being asked for here.
But these facts are different in this case. There's no sham. There's no connivance. There was full disclosure to Twin City. They knew what was going on from the beginning to the end. What really is going on here is the carrier wants basically everything. It basically wants to throw the policy that caused the Supreme Court to decide Aikens the way it did out the window.
Your Honor, that's absolutely false.
I mean,
Because
we
the
look at
cases,
we look at the
yes,
cases,
and they're crystal
we look
clear.
at the cases, and the reality is that what strikes me is Twin City wants to take the facts of the cases and cherry pick some of the sentences and ignore the context of every single case. And I see nothing in Aikens, for example, that says you have to have a trial. It has to be adjudicated. In that case, there was an adjudication. And Stout emphasizes over and over again, Stout 1, that the issue is that you had a third-party action, it settled the policy limits, and there's no evidence that employer fault affected the offer to settle. That's not this case. That's just not this case. This case, as far as I can tell, is the first case that has come up where there has been above board, carrier approved settlements where it appears that the employer's fault has been well established here. Well established. So this is maybe the first time this has come up and has come to the Court of Appeals, but it's the first type of I case. So you can say, and no other cases has the carrier these facts in such a pristine way been surfaced.
Your Honor, I totally disagree. There were 6 defendants involved here, and several of those in the last one put up their policy limits for $1 million each. In fact, you had asked earlier about what about Glendale. What happened, in fact, is that, if I can find it very quickly, is that as Mr. Slack testified, he said, I remember we made a policy limits demand on the other entities which would allow the city of Glendale not to have to pay anything.
Okay.
They allowed them to walk away. That is page 12 of Mr. Slack's deposition. Every single policy, every single third party put up policy limits.
Except for the city.
Because they offered that, because that was part of their offer,
Well,
according to Mr. Slack, that allowed them to walk away. They weren't going to let Glendale off the hook unless all of the other carriers put up for $1 million each, and they did.
Well, I
They
don't think
did.
it was $1 million. But as respects Ms. Leija, it wasn't $1 million.
It was
each.
I'm talking about the policy limits, so it was collective. They went collectively. Counsel for both Ms. Leija and Mr. Stockman went collectively to the carriers and said, we will let the city off the hook if, and that's according to Mr. Slack's own testimony, if all of these insurers, all the insurers here put up and $1 million, put up their policy limits, and that's what they did. So this is exactly like Stout.
Well, except
in
for
that
the city.
Isn't this case?
they let them out, Your Honor. How can they come
Another
back
way of
in and
putting
then
it is
get
they
them?
settled. Another way.
But there's no indication that that is because, Your Honor, and Grijalva talks about that, there has to be proof. There has to be a reduction, a proof in what they're accepting, not what they could have received at trial, but when there's an acceptance of policy limits, in which there were with respect to every single third party here. Then the court says that is what has motivated the settlement, is policy limits. You cannot just simply imply or read in or hold a post hoc proceeding after the fact to find out what the motivations were of the plaintiffs in settling, and that it was motivated by employer fault.
The motivations. Would you agree with me that other than the statutory duty to notify of the claims and to get approval of the settlement, the employee owes no duty to the carrier, other than that limit scope, correct?
Correct.
And would you also agree that a plaintiff in any kind of lawsuit is always going to try to maximize their total recovery?
Of course.
So it seems to me that if they're suing a certain class of defendants, they're going to be motivated for that class to get the most from that class, and then they switch to a different class of defendants and try to maximize from that class and minimize the other class.
Yes, but what they're asking for here, Judge, is to do it in the context post-settlement, post hoc, for the sole, and this is the operative language in Grijalva and Stout, that the proceeding is for the sole purpose of forcing the carrier to reduce and compromise its lien. That is what Grijalva does not allow. Here, they made a choice.
Grijalva was a weird set of facts because you had, in your words, a sham trial, in the Supreme Court's words, a summary trial. I actually agree with your characterization. Doesn't it look like, from the reading of the case, I don't think it's entirely clear that the carrier was never given an opportunity to litigate, and that was the Supreme Court's primary concern, is that we had two parties engaging in litigation that affected the rights of a third party, where that third party had no participation, no invitation to participate, and where the two parties that were litigating, neither one of them had similar interests.
That is not what the case says, with all due respect, Your Honor, and Stout reaffirms that. That is this court's reading in Stout of Grijalva. The emphasis is not on, well, it would be okay if the carrier were involved. The emphasis is you cannot, and this is under a long line of cases, starting with and going even before the Boy case that Grijalva talked about, that Aitken talked about, that Stout talked about, that repeatedly emphasized that the carrier has an absolute right to not compromise its lien and to demand full reimbursement of the lien. Aitken is a very narrow exception to that resulted from the imposition of comparative fault in Arizona, because before, back when it was joint and several liability, you could collect for the employer's share of the fault, but it is not fair, and this is the problem that is created, and this is the inequity that Aitken was trying to address, is that where the employee cannot sue the employer and the jury apportions a certain amount of fault to the employer, that automatically, as a matter of law, no questions asked, reduces the recovery, reduces the award of that employee, then it is not fair to then also allow the carrier for the employer to then get the full amount of its lien. But the cases after that talk over and over again, including this court and including Weber, frankly, had the exact same interpretation as this court, that once you settle, and especially if you've got a settlement for policy limits, which is here, all of them, then you can't go after the fact and force the employer to compromise its lien.
Refresh my memory, because I don't recall off the top of my head. Did either Grijalva or Stout involve facts such as this, where there were essentially two sets of plaintiffs and we had a settlement for policy limits, and those policy limits had to be split between two plaintiffs?
No, Your Honor, but that was frankly never raised as an issue, because the choice to settle, and these cases do talk about that, is the plaintiffs in a third-party action. There are risks going either way, and one thing that you do, why even have a settlement here if they can come and get the results of what they would get in going to trial against the carrier and still get it to compromise its lien based on employer fault, that it did not roll the dice, that they did not roll the dice to go in the first instance to trial to have apportioned. That's what's unfair about it, and that's what makes it a sham proceeding.
Going back to your notion, I've been mulling it over about the decision by the plaintiffs to allow, in your words, to allow the city off the hook because they collected policy limits from all the other defendants.
Yes, it was contingent on that, actually.
Okay. It seems to me that that if the workers had gone to trial against all of the third-party defendants, in settling that case, they were weighing what they would get at the end of the day. And at that trial, they would get something less than their full amount of damages, because the jury necessarily would have allotted some degree of fault to the employer. Isn't one reasonable way to look at the analysis from the worker's perspective vis-a-vis the settlement with the city is they figured out what their total damages were. They figured out what the range of fault might be appropriated to the city. I'm sorry, to the employer, and the policy limits of the subs without tapping into the city. That was about what they were going to get.
You're saying as far as the policy limits.
Right. So that the settlement that the plaintiffs in that case ended up accepting was reduced. The amount to the injured workers in that settlement was reduced in accordance with employer fault.
I think you're reading that into it, Judge, because that's where Grijalva and the other cases talk about where it is done for policy limits for all of the policies. That is what you need to look at. And I just want to add, if there is
but I don't. I'll let you go on. I'll let you
Okay.
add. But answer me this: the city didn't settle at its policy limits. So how can you say, well, that didn't apply here?
there's nothing
There were more dollars there to be
Right.
had at trial, but for employer fault.
There is nothing in the record that indicates that. Mr. Slack, in fact, when they talked about the motives and asked Mr. Slack about the motives for doing it, he didn't say because of employer fault. What he said was, well, I'm not going to get into, my client's motivations for settling. And Grijalva and these other cases talked about that fact, that there are many reasons for settling, many. And and where it's policy limits, you can't read into it or make a finding that it was reduced for employer fault.
Okay.
And just the only other point I wanted to make is if there is a perceived inequity here, there is no mechanism in the statute that allows for this kind of a proceeding. Frankly, in the Florida statute that Ms. Leija's counsel cites, there is. Where there is evidence that an employee settled for less than his full or fair amount of damages, then the trial court is required to hold a proceeding after the settlement for purposes of determining if the carrier's lien should be reduced. We do not have that here. Okay. This is for the legislature to change, not for the court, unless the court is ready to overrule Stout and other prior cases.
Thank you.
Thank you.
Would you add 2 or 3? What do you think?
Couple minutes.
Oh, 2 minutes, please, to Mr. Ramos' time. Wait, don't start yet.
Okay, I'll wait until it starts going down before I start.
We're good. Go ahead.
Okay. Thank you, Your Honors. I'd like to address the points that defendant raised in order, but I'm going to skip the order just to say that Aitken wasn't determined because of a statute. It is an equitable finding. The last statement that the defendant or that the appellee made was just incorrect. The first statement she made, though, was that, we treated Mr. Leija fairly or Mrs. Graciela fairly because she settled for the same percentage at Mr. Stockman, apparently forgetting that Mr. Stockman was the person who left the bolts off of the machine that fell over the edge of the building, and we got the same amount of a reduction as he did, the guy that left the bolts off. And that's supposed to be equitable. It defies the imagination, but also consider this. Mr. Leija is dead, whereas Mr. Stockman has the ability with the Affordable Care Act, at least as it existed at the time, to be able to go and get insurance at a reasonable rate. So the fact that they paid the same amount for these two actually showcases the inequity of their actions in this case. There is nothing unfair about allowing us to come forward and present a position which is basically the same one that we always presented, but with a different emphasis. We've always acknowledged there's been employer fault. We may have made the bullets that they will use to fight against us, which is fine. That's the way court is. Facts are presented by parties with the proper motivation, and in this case, the proper motivation is that they come forward and make their case against the other parties, which we provided them the ammunition for, and we make the argument against the employer. At the end of the day, what we're left with is that in this case, it is a special case, because unlike the other cases, we got their permission, and that puts us in a different spot. So the question becomes, what do we do with this? And if we use Aitkins as our guiding rule, what we want to do is to provide a fair trial for them and a place where they can determine what the lien amount is that they should reduce by. Remember, in this particular case, the adjuster was a liability adjuster that was adjusting the workers' compensation claim. The attorney that they hired, Pat Howell, is a liability attorney. And the reason that they hired him is because insurance companies make money because one of two things: amazing luck that happens year after year that allows them to build big buildings, or because they're smart and they hire people that adjust claims. In this case, that's all we're asking, that we use Aitkins as our guiding star and not allow a double collection, but allow a fair trial with proper motivations. Just take one example. If there's a $15,000 policy out there for a car, and it hits a truck that's brakes are faulty, and there's a $10 million worth of damage, under their reading of Aitken in the following cases, they can hold them to go to trial because they have no duty at all to fairness, even if the vast majority of the liability is on the employer, even though the damages are $10 million, they can sit on their, they can basically extort money from an insured by saying, you have to go to trial. We have no duties, and that's wrong. Thank you, Your Honors.
Thanks. Thanks to all the lawyers for your briefing and your argument. We are grateful for them. We will issue a decision in due course now. We stand adjourned.